Okay, today is Monday, March 17, 2014. This is Julio, Zamora, 1385 El Camino Way, Los Banos, California. I'm making a statement for trial at Workmen's Comp with Judge Grill's court. And I should note that I work for Safeway. I was hired in 2002. I was born September 7th, 1940. I'm 73 years old. Moving right along here. Safeway and Local 439 in Stockton, California are under a union contract, International Brotherhood of Teamsters. I want to start this off by reading Article 25, Discharge and Disciplinary Procedures. Okay, so it says the company may discharge or otherwise discipline an employee for just cause. The company shall not proceed with any interrogation unless the employee being interrogated is provided with union representation. Okay, so we know that. And it says that the suspension and discharge notices must be issued to the employee with a copy sent to the union by certified mail within 20 calendar days of the event giving rise to the violation, or when the company obtains knowledge thereof of the offense for suspension or discharge. Must be sent and postmarked to the company within 10 calendar days of the union's receipt of the notice of suspension or discharge. If the company fails to send such notice within the time limits, the right to suspend and discharge is waived. Well, they didn't file a grievance within 10 days. Okay, they didn't complete step 1, so I'm gonna go on ahead and read step 1, Article 26, General Grievance Procedure. Okay, step 1 says that any grievance shall be filed in writing within 10 days of the day the grievant knew or should have known of the alleged incident, with the specific contractual violation clearly indicated. The matter shall be discussed with the grievant, the steward, and the department head. Any grievance not filed within this 10-day time limit will be considered null and void. The department head or his designee shall respond to the grievance in writing to the grievant within 10 days of the grievance, or the grievance shall be deemed resolved in favor of the union. Okay, so we know that. Okay, within 10 days. Okay, that's step 1. Okay, and they got to send registered mail. And they didn't do that. Okay, they didn't file agreements within 10 days, and they didn't send any registered mail. They emailed it. Okay, moving right along here on page let's see, what was that page? Page 25, step 3. Okay, step 3F, okay, it says that a decision reached with step 1 of the grievance arbitration procedure shall be final and binding on the parties and the employees. Okay, from step 1. Now we know they didn't file a grievance within 10 days and they didn't send any registered mail. Okay, and on page 25D, it says the jurisdiction and authority of the arbitrator over the grievance and the opinion and award shall be confined exclusively to the interpretation of the explicit provisions of this agreement and issued between the union and the company. So, okay, so we know it's null and void, final and binding, and they have to file agreements within 10 days. Okay, so we know that much. So, the next thing is that On Thursday, December 16, 2010, the union received General Teamsters Local 439 in Stockton, California, received a grievance, received December 17, 2010. And the incident was December 6, 2010. That's 11 days. That's not within 10 days. So they didn't meet the time limits. So there's no issues. Null and void, final and binding. Okay, so I have another letter here. That letter was dated Thursday, December 16, 2010. Received December 17, 2010. Safeway. That's the title head of the document, the agreement that they filed. Okay, so they, what did they do here? I guess they, it says via fax and mail. Doesn't say registered mail. It says fax and mail to Local 439. Now, on December 17, 2010, the union received General Teamsters Local 439 is responding within 10 days, okay? And it's via email to James Williams, 18 at Safeway.com, via fax, 209-833-4871. To James Williams, Transportation Manager, Safeway Distribution Center in Tracy, California. Reference Julio, Zamora Transportation. It says, Dear James, in accordance with Article 25 and 26, all other applicable articles of the CBA, considered this a formal grievance protesting the unjust, improper, and without just cause discipline issued to Mr. Zamora in a letter dated December 16, 2010, in violation of Article 25 and all other applicable articles of the CBA, etc. And then it goes on to say that the local union requests the discipline to be denied, grievant to be returned to work immediately, and the grievant to be compensated for any and all lost time and benefits. Please provide a date and time to discuss the grievance in accordance with Article 26 grievance procedure. Additionally, please provide any and all supporting documents, notes, trip, sheets, videos, and statements surrounding to the investigation and discipline issued to Mr. Zamora that the company relied upon as soon as possible, but no later than December 25th, 2010. Okay, and then it goes on to say, if you have any questions, sincerely, Sam Rosa, Secretary Treasurer. By Robert Nicewanger, Business Representative. And a copy of this was sent to Carl Ramirez, Safety Labor Relations. They emailed it. Okay, and Ben Pioshay, Pioshay. I don't know who that is. And then Ed Specklin, Mike Sadler, and then it says Julio Zamora. So that's the reply to the grievance that was filed or received December 17, 2010. They told them to put me back to work. They didn't file a grievance within 10 days, and they didn't send registered mail or anything else for that matter. So we know that much. Okay, so now, moving right along here, I was on FMLA in 2008, 2009, and 2010. They refused it, so I had to get a third opinion. Okay, so I got a third opinion, and I got the document right here from third opinion from Nationwide Better Health. Okay, it's dated December 13, 2010. Okay, so now It says Julio Zamora, 1385 El Camino Way, Los Banos, California. And then it goes on to say, reference your leave of absence in Family and Medical Leave Act, FMLA. Dear Julio Zamora, Nationwide Better Health is a third-party administrator for Safeway leaves of absence under the Federal Family and Medical Leave Act, FMLA, and applicable state laws and company policies. It says, we are writing to inform you of the qualification status of your FMLA intermittent leave period number 293330 for your own serious health condition. This period has been qualified as FMLA leave from 10/13/10 through 10/12/2011. Let me say that again. From 10/13/2010 through 10/12/2011. Therefore, all leave taken for this reason will be designated as FMLA leave. Please note that the certification from your healthcare provider indicated the expected duration and frequency of your absence. 1 day a week as long as FMLA time is available. So we know I'm on FMLA, and like I said, the letter dated December 13, 2010. I'd also like to note, along with this third opinion, okay, on a letter dated Wednesday, February 11, 2009, corrective action written warning. You have accumulated more than 22 points over the past 6 months in violation of our no fault attendance policy. Okay? So I'm going to go on and here it says that I was on FMLA in 2008 and to 2/8/2009. It says here sick 2 days, disability 1/14/2009 to 2/8/09. They charged me 12 points. And then on it says no show, no call. I was on FMLA. They charged me 8 points. And then on the 12/26/2008, they gave me a verbal warning and they gave me 8 points, and I was on FMLA. On 12/21/2008, I was excused on 12/21/27, and it says FMLA, but I wasn't excused any other time. So I don't know, and they know I have a serious health condition. And it goes on to say you are hereby being issued this written warning as a contractual required. Any additional unexcused absence and or points may result in further disciplinary action up to and including termination. Okay, it was signed below, acknowledged receipt of this letter on 2/11/2009. Now, I didn't sign it because I was on FMLA and I was on disability and they were penalizing me. And that was in 2009. Oh, it's on the other page it shows that I signed it on 1/7/2009. The union shop steward signed it, and driver supervisor signed it. And it says Human Resources, Local 439, Employees File. So we know I was penalized while I was on FMLA in 2009. So we know that much, okay? So moving right along here, they didn't put me back to work, okay? And I filed for unemployment. Okay, so I have a letter here, claim effective date 1/24/2010. Okay, and they mailed this on 10/26/2012. It says you have provided information which indicates that you may be entitled to workman's compensation benefits. However, since your entitlement to workman's compensation cannot be determined by your employer or their insurance company at this time, the Employment Development Department, EDD, will pay your claim if you are otherwise eligible. If you should receive workers' compensation after EDD has commenced benefit payments, you must immediately contact the SDI office handling your claim. Existing law provides that you are not eligible for state disability insurance, SDI, for any day that you received or are entitled to receive workman's compensation benefits equal to or in excess of your SDI entitlement. Conflicting workman's compensation benefits include temporary disability payments made to you by your employer or their insurance carrier. Okay, on the top of this letterhead it says notice of conflicting liability. Notice of conflicting liability. So we know that they're liable for my back wages according to this letter and according to the document December 17, 2010. The union emailed it to James Williams, the transportation manager, to put me back to work with all back pay and benefits. Okay, and the discipline to be denied. Now we know that. Okay, moving right along here. I'm still not back at work, okay? Moving right along here, like I read before about the FMLA. I'm on FMLA, right? I have an attendance control policy, no fault attendance policy, company policy. On item 3, attendance control policy, it says tardy. Late arrivals, early departures will be charged 2 points for up to the first 2 hours and 1 hour for each hour thereafter, up to 8 points per day. Okay? It says the following progressive discipline shall be issued to the employee that are in violation of the above described point system. Okay, so we know we have the no fault attendance policy. And this is our new hire packet truck drivers part 2. Welcome to our Safeway team. We are glad to have you join our company. Safeway cares. And it says employee retained for their records. So that's what I did. I kept the company policy. Okay, moving on along, I haven't worked all this time since December 7, 2010. And I should note that when they sent me home, they didn't let me clock out. So I'm still on the clock. And like I said before, I was hired in 2002. Now, due to the fact they didn't let me clock out, anybody that works underneath me, and I got 200 truck drivers underneath me, I should get paid for that day. Okay, and it's a 24-hour operation, 7 days a week. And we got 1,500 Teamsters employees there. So, moving right along here, we know that they didn't file a grievance within 10 days, and they didn't complete step 1. So they need to pay me all back pay and benefits from December 7, 21, as they were instructed to do so by the letter dated December 17, 2010, by the International Brotherhood of Teamsters, Mr. Nicewanger. Well, they didn't do that. But in any event, they got to pay me every day that somebody works underneath me according to seniority. And I'm still not working. Okay, moving right along here. In 2011, they had a panel hearing. In 2011, they had a panel hearing on January 11, 2011. Now, why they had a panel hearing, I don't know, because the grievance was never filed. Okay, I'll say that again. Our grievance was never filed in January 2011. You got to go 10 days back. So if you go 10 days back from the panel hearing, which was January 11, 2011, set by Mr. James Williams, Transportation Manager, why? I don't know, because the grievance wasn't filed. I don't know what the issues are. But I did find out later in 2011 that they made false accusations regarding punching in late on the time clock. They said I intend to falsify documents. Well, they didn't file a grievance within 10 days, and there's no issues. Null and void found and binding. So there was no grievance filed. They made false accusations that I punched in late when I should have been charged 2 points. Company policy, no false attendance policy. Well, they didn't do that. They accused me of falsifying documents, which is impossible. Okay? Because the federal government has all trucking companies install a data machine in the tractor, and they're tamper-proof. There's no way a driver can falsify anything. Okay? You have to have a key to the master computer in order to change anything on them logs, okay? We go by logs. They print out algorithm sheet, and it's not to be altered in any way, okay? They're not allowed to do that, and the driver's not allowed to do that. So in any event, the fact is, it's tamper-proof. But anyway, nothing transpired over that I'm aware of, because there was no grievance filed. So there's no issues. And the fact that we have a no false attendance policy, company policy that I was issued in 2002, I don't know. I'm confused because there was no grievance filed within 10 days. They had a panel hearing. Why, I don't know, because they put it in abyss, and they sent me home when I told them I had a severe, profound hearing impairment. And I got a legal document to that because Judge Grill ordered it. So I didn't understand what's going on, and they sent me home. They put the panel hearing in abyss, and they sent me home when I told them I had severe, profound hearing impairment. And I told that to the shop steward and the BA, Mr. Nicewanger, local 43019 from Stockton, California. Okay, moving right along here, there was no grievance filed in 2011, and they made false accusations, and then, so I don't know, there's nothing became of that I'm aware of. I don't know what to say. Anyway, moving along here, I have a letter dated September 29, 2012, Safeway letterhead. It says, reference employee, Julio Zamora, employer Safeway Incorporated, date of injury 2/25/2010, claim number W1197861. And it goes on to say, Dear Mr. Zamora, attached for your review and completion is a notice of offer of regular work, DWC-AD 10118. Please be advised that absent your termination from your employment, and I wasn't fired, I was supposed to report back to work. They were instructed to put me back to work. And it was emailed to James Williams, the Transportation Manager, Distribution Center in Tracy, California, but he didn't put me back to work. Okay, going on to say, please be advised that absent your termination from your employment based on the P QME report from Dr. Portnoff, Portnoff. Your employer is able to offer you regular work. And then it goes on to say, please call your attorney for any additional questions. Sincerely yours, Lorna, MOLDES, Claims Examiner 2, 209-833-4805. Enclosure, DWC-AD10118. Return envelope, proof of service. And it was sent to John Gonzalez, ESQ. Central Valley Injured Workers Clinic, Incorporated. P.O. Box 3247, Modesto, California 95353-3247. And another copy was sent to Joseph Belupo, ESQ, P.O. Box 7859, Stockton, California 95267. So they were all notified. It's not like they didn't know, okay? And then I got a letter here, Central Valley Injured Workers Legal Clinic, Incorporated. Okay, dated October 17, 2012. Julio, Zamora, 1385 El Camino Way, Los Banos, California, 93635. Reference, your Workmens compensation case. Dear client, I note that the employer has offered you regular job. Please immediately report to work and make sure that you get a copy of this acceptance to your employer. Sincerely yours, Central Valley Injured Workers Legal Clinic, Incorporated. John Gonzalez, attorney for the applicant. Okay, so we know they didn't file a grievance within 10 days. They didn't file a grievance in 2011, and they didn't put me back to work according to the email that was sent to James William Transportation Manager on December 17, 2010, and he didn't put me back to work. Now, now they sent me to a psychiatrist, and I have no idea, but I went to the psychiatrist, and then he says I need 8 visits, I need to be counseled, because I have job stress. And he left it up to the judge to decide whether it's work-related or not. So I'm making an appointment for that, and then I guess we'll take it from there, but I gotta say, I should be working all this time. There's no reason why I should not be working, and the question is, in my mind, which I'm going to mention to the psychiatrist, is the fact that will Workmen's Comp Judge will enforce a union contract. The letter dated December 17, 2010, to put me back to work with all back pay and benefits from December 7, 2010. And will he enforce the notice of offer of work? And also the FMLA that I read, and that's on my mind. I'm stressed because I haven't been paid in going on 4 years, and I'm also stressed because I don't know what the judge is going to do about this. I don't know if he's going to enforce the contract, enforce the FMLA, is he going to enforce the notice of offer of work, and is he going to enforce the letter that was sent to Safeway Distribution Center in Tracy, California, to report to work, and they didn't do it. Is he going to enforce the document that stands for them to put me back to work? Those are my thoughts, okay? Those are my thoughts for today. And today is Monday, March 17, 2014. So I'll make an appointment to see a psychiatrist. Hopefully she'll send a letter to my attorney. What she's going to decide, I have no idea. So anyway, that's my statement. Those are my thoughts. And until then, today is March 17, 2014, like I said before. Until then. I'd like to note one thing, the fact that the notice of offer of work became effective December 15, 2010. The notice of offer of work became effective December 15, 2010. And I should also note that the fact that I was on FMLA and that I worked the whole year of 2010, I wasn't on leave, I wasn't on disability, and the company didn't put me on leave. They stopped paying my health and welfare on December 7, 2010. So I've had no medical coverage since December 7, 2010, and I was on FMLA. So again, the question in my mind is that is Judge Grill going to enforce the FMLA because I don't have any medical coverage? And is he going to enforce a notice of offer of work that I should have been working on December 16, 2010? But the union didn't receive the grievance until December 17, 2010, and the incident was December 6, 2010. That's 11 days. So that's the end of that, and God bless until then.